Hi, I'm Karl Konrad and I'm part of the team at Australian Immigration Law Services. Why is South Australia changing their occupation list without any announcements or advice? The New South Wales 491 sponsorship program is off to a non-uniform approach between RDAs, and the Australian Chamber of Commerce and Industry has added its weight to the call for relaxing immigration rules for employer-sponsored visas. All this and more, and this is the latest news in Australian immigration. After facing fierce criticism from migration professionals and students who have studied in South Australia, the government silently slipped the occupations of accountant, management accountant, taxation accountant, cook, and cafe and restaurant manager back on their 491 and 190 sponsorship lists. However, the three accounting occupations have now been restricted to applicants who can meet the Talent and Innovators program only. This is still a blow to many accounting students hopeful in South Australia, but at least it's better than not being on the list at all. Regional governments need to be consistent if they are hoping to attract international students to their states and territories. So far, Tasmania and the Northern Territory have been the only regional areas that have managed this well. New South Wales gets away with being unreliable with its occupations list only because they know students will come and study there anyway, but even that arrogance can backfire eventually. The New South Wales 491 sponsorship program that opened last month held the hope of sponsoring offshore applicants, but unfortunately that is not the case. Each region is deciding what stream they want to sponsor, and with regards to offshore applicants, Central Coast RDA says this: due to the request from the Australian government to prioritise onshore applicants and the national border restrictions because of COVID-19, offshore applicants will not be considered until further notice. And it's not only people who are offshore who are feeling a little left out. Depending on the region, not even international students studying in regional New South Wales, which falls under Stream 2, get a fair look in. Again, Central Coast RDA is a prime example, where they say RDA Central Coast is currently only accepting applications under Stream 1 only, and no exceptions will be made. We thought when the New South Wales government introduced its standardised nomination criteria, it would put an end to the various RDAs making their quirky requirements. However, this hasn't stopped some of them from developing their own setting of rules. Certain RDAs have skill availability form to ensure certain occupations are not oversubscribed. So even if your occupation is on the list, they just may not want more of you. The Irana RDA states that individual RDAs have some additional criteria requirements for some occupations, and please check individual RDA's websites before making an application. So much for the uniform nomination across New South Wales, and it's a feeling of déjà vu of the old problems of the past with regards to 491 sponsorship. The Western Australian Kalgoorlie Goldfields Dharma program has been updated and expanded from 75 to 125 occupations, and 3 extra shires joining the agreement. Dharma programs are great for they allow an older upper age limit of 49 for skills level 2 to 4 occupations and 54 for skill level 1 occupations. Certain occupations can also be paid below the standard $53,900, which include age or disability carers, personal care assistants, nursing support workers and childcare workers, to name a few. Dharma arrangements use the 482 and temporary resident visa and the 186 visa for the permanent resident pathway. This means your employer can sponsor you from the 482 visa to the PR 186 visa if they like you. The Australian Chamber of Commerce and Industry has recommended an overhaul of the skilled migration program so businesses in Australia can recover as quickly as possible from the pandemic. They have called for an expansion of the priority list of occupations that can be sponsored and exemptions sought for entry. They call for the support to need to resolve a clearer pathway to international travel restart. They claim the current system of quarantine caps, where all arrivals are treated as being the same risk, is not working effectively. All temporary migrants in Australia who are with or who can find an employer to sponsor them be eligible to apply for permanent residency under the employer-sponsored skilled visa, provided their occupation is at ANSCO skills level 1 to 3. reduce the cost of employer sponsorship for permanent and temporary skilled migrants at least for the next 12 months, and recommends halving the Skilling Australians Fund migration training levy on a long-term basis. A new bill introduced to Parliament outlines it is no longer appropriate to hold people in detention indefinitely. Under this bill, immigration detention for non-citizens and refugees must be lawful, necessary, proportionate, and be for the shortest possible time. Mandatory detention will be illegal under this bill. This bill clearly outlines the reasons and the timeframes, communication and services that are to be available in immigration detention and will be independently monitored. It ensures all decisions are subject to independent oversight and prompt review. Now, we're not sure if this bill will pass into law, but it's long overdue in this country and worth a try. Our team is always there to assist those who need professional advice, so reach out to us and arrange a consultation using Zoom, Skype, or the telephone. Don't forget to like this video to support this channel and hit the subscribe button if you want the notifications of our weekly videos on a whole range of immigration law topics. Thanks for joining us today, and as always, take care out there, and I will see you next time. So bye for now.